The certified letter sitting on my kitchen counter looked official enough to scare most people. But I'd been dealing with bureaucratic nonsense for the better part of 20 years as a property surveyor in rural Montana. What caught my attention wasn't the legal jargon threatening foreclosure on my family's cabin, but the signature at the bottom belonging to someone named Patricia Henderson, president of the newly formed Pine Ridge Mountain Estates Homeowners Association. My name is Lucas Vaughn, and I inherited my grandfather's cabin 3 years ago when he passed at the ripe age of 92. The property sat on 40 acres of pristine Montana wilderness near Whitefish, a place where my family had spent summers since 1947. The cabin itself was modest, built from local timber, with a stone fireplace my grandfather assembled rock by rock. It wasn't fancy, but it was ours, completely paid off, and most importantly, it existed long before anyone thought to carve up the surrounding forest into luxury vacation properties. I read through the letter again, my coffee going cold in my hand. According to Patricia Henderson and her board of directors, my cabin violated no fewer than 17 covenants, conditions, and restrictions that apparently now govern the area. The list was absurd. Wrong roof color, unapproved exterior paint, non-compliant mailbox, vehicle visible from the road, firewood stacked in an unapproved manner, and on and on. They demanded I remedy all violations within 30 days or face seizure of the property for failure to maintain community standards. The thing was, I never signed anything agreeing to join their HOA. My property predated their development by more than 70 years. I grabbed my phone and called my buddy Derek, a real estate attorney in Kalispell. "Lucas, my man, how's the surveying business?" Derek answered on the second ring. "Been better. I need you to look at something. Can I come by today?" "Sure thing. I've got a slot at 2. I spent the morning pulling every property document I had from my grandfather's old filing cabinet. Deeds, surveys, easements, water rights, everything dating back to the original land patent. My grandfather had been meticulous about record keeping, a trait I'd inherited along with his property. Derek's office occupied the second floor of a historic building in downtown Kalispell. He took one look at my face and poured us both coffee without asking. "That bad?" he said. I handed him the letter. He read it, his expression shifting from curious to incredulous. "They're threatening to seize your property. The cabin that's been in your family since Truman was president. That's what I'm reading. Can they even do this?" Derek flipped through the pages I'd brought, scanning documents with practiced efficiency. "When did this HOA form?" "No idea." "First I'm hearing of it. And you never signed a declaration of covenants?" "Never. Wouldn't have. You know me." Derek leaned back in his chair, tapping a pen against his desk. "Here's the thing. They can't just unilaterally impose HOA rules on existing properties. You'd have to consent to join. Since your property predates their development, and assuming you never signed anything, they have zero authority over you. So this letter is garbage, legally speaking, yes. But that doesn't mean they won't try to make your life difficult. HOAs can be remarkably creative when they want something." Derek paused, studying one of the old survey maps. "Wait a minute, this is interesting." "What?" "This easement here." He pointed to a line running through my property. "Explain this to me." I looked at the map, recognition clicking into place. "That's the access road, the only road into the valley where all the new development is. It cuts through the northwest corner of my property." Derek's eyes lit up. "And who owns the easement?" "My family granted it back in the 60s to the county for access purposes. When they paved Forest Service Road 219, they needed to cut through our land." My grandfather agreed. with the stipulation that the easement could be revoked if the road was ever privatized, or if it ceased to serve its intended public purpose. You have the original easement agreement. I rifled through my papers and found it, a yellow document with my grandfather's signature and a county clerk's seal from 1968. Derek read it carefully, then read it again. "Lucas, this is gold, pure gold. The terms here specify that the easement is granted for public access to federal forest lands. If that road is now primarily serving a private development, and if they are trying to restrict who can use it, you might have grounds to challenge the easement." I'm not following. Derek stood up, excited now in the way only lawyers get about obscure property law. Think about it. They built their entire development assuming access via this road. If that access goes away, their property values tank. They'd be landlocked except for a fire road on the far side that's basically impassable half the year. So you're saying I have leverage. I'm saying you have a nuclear option, but let's not get ahead of ourselves. First, let me do some research. I want to know exactly who these people are and what they think they're doing. I left Derek's office feeling better but still annoyed. I'd planned to spend the weekend at the cabin, doing some maintenance before winter really set in. Instead, I was dealing with bureaucratic nonsense from people who probably just moved to Montana last year and thought they could dictate how a fourth-generation property owner maintained his family's land. The drive to the cabin took 90 minutes from my place in Columbia Falls. The road wound through thick pine forests, climbing steadily into the mountains. When I reached my property, I slowed down at the gate, noticing something new. Someone had installed a fancy stone and timber sign reading Pine Ridge Mountain Estates, a gated community, right at the point where the road crossed onto what I was pretty sure was still technically my land under the easement terms. I parked at the cabin and walked the property line, checking boundaries I'd surveyed myself 2 years ago. Everything looked correct. My 40 acres were exactly where they'd always been, an irregular parcel that predated the modern subdivision of the area. The new development surrounded me on 3 sides, with Forest Service land on the 4th. The new houses were massive, modern constructions with walls of glass and metal roofs. They looked like they belonged in an architecture magazine, not the Montana wilderness. Each sat on 2 or 3 acres, and I counted at least 30 completed homes with more under construction. As I stood there, a white Lexus SUV pulled up to my fence line, and a woman got out. She looked to be in her mid-50s, with blonde highlights and expensive workout clothes that had probably never seen actual exercise. "Excuse me," she called out, her tone already confrontational. "Are you the owner of this property?" "I am. Lucas Vaughn." "I'm Patricia Henderson, HOA president." "Did you receive our letter?" "I did." "And are you going to address the violations?" I kept my voice level. "There are no violations. I'm not part of your HOA." Her expression hardened. "Everyone in Pine Ridge Mountain Estates is part of the HOA. It's non-negotiable." "My property isn't part of Pine Ridge Mountain Estates. It predates your development by 70 years. "That's irrelevant. You're surrounded by our community. You benefit from our roads and security. You need to comply with our standards." "Your roads? That's interesting." "Because the road you drove in on crosses my property via an easement my grandfather granted to the county in 1968. Patricia waved her hand dismissively. "Ancient history. The developer acquired all necessary easements when the project was approved. Did he now? I'd love to see that paperwork." "I don't have to show you anything. I'm here as a courtesy to inform you that if you don't comply, we'll take legal action. This community maintains certain standards, and your property is an eyesore that affects everyone's property values." I looked at my cabin, at the honest logs and the stone chimney, at the garden my grandmother had planted that I still maintained every summer. An eyesore, right? 30 days, Mr. Vaughn. Paint your cabin the approved colors, install an approved roof, relocate your vehicles to an enclosed garage, remove that firewood, and submit all plans to the Architectural Review Committee for approval, or face the consequences. She got back in her Lexus and drove off, leaving me standing there getting angrier by the second. Nobody threatened my family's property. Nobody. I called Derek from the cabin porch. They just got a lot more hostile. Tell me. I relayed the conversation with Patricia Henderson. Derek listened without interrupting. Okay, he said when I finished. I did some research after you left. The development was approved by the county 3 years ago. The developer was a company called Summit Ridge Properties, LLC. They've built out about 60% of the planned homes. The HOA was established 2 years ago, and they've been aggressive about enforcement. What about the easement? That's where it gets interesting. I pulled the county records. Your grandfather's original easement was never formally transferred to the developer. It's still in the county's name, granted for public access to federal lands. But the developer built the road following the same route, and apparently everyone just assumed the access rights transferred. But they didn't. Not automatically, no. The county would have to approve any transfer, and the terms of your grandfather's easement would have to be met. I don't see any record of that happening. So what are my options? Well, you could revoke the easement. It's within your rights under the terms your grandfather set. But that's extreme. It would cause major problems for everyone in that development. Maybe they should have thought about that before threatening to steal my property. I get it, Lucas, but let's be strategic. How about I draft a response to their letter, making it clear you're not subject to their authority and that any attempt to place a lien on your property will be met with legal action. We'll also mention, casually, that you're reviewing the status of the road easement. Just to remind them who has the real leverage here. Do it. Derek's letter went out 3 days later. The response was swift and came from an attorney representing the HOA. It was 5 pages of legal posturing, asserting that my property was subject to the HOA by virtue of being within the development's boundaries, and that I had been unjustly enriched by the improvements the HOA had made to common areas and roads. They demanded I pay 3 years of back HOA dues, totaling $8,000, plus a $5,000 special assessment for a new security gate they'd installed. The letter also informed me that the HOA board had voted to place a lien on my property for non-payment of dues and non-compliance with community standards. They had 30 days to do so under Montana law, and they would. I met Derek at a bar in Whitefish that evening. He'd brought more documents. They're bluffing, he said, spreading papers across the table. They can't place a valid lien on property that isn't subject to their authority, but they can file one, which creates a cloud on your title and makes things messy. How messy? You'd have to sue to remove it. It's expensive and time-consuming, even though you'd win. They're counting on you either giving in or not having the resources to fight. They don't know me very well. There's another issue. Derek pulled out a map. I did a deeper dive into the road situation. The county has been maintaining that road as a public access route for years, but when the development went in, they stopped. Now the HOA maintains it and claims it's a private road. They've even got that security gate at the entrance. The gate isn't on my property, is it? No, it's about a quarter mile past where the easement ends. But here's the thing. If they're restricting access and claiming it's a private road, they're in violation of the easement terms. Your grandfather granted access for public use to reach federal lands. That means anyone should be able to use it. I sipped my beer, thinking, what happens if I revoke the easement? Chaos. Those 60 homes become almost landlocked. There's a fire access road on the east side, but it's not paved, it's steep, and it's snow-covered at least 4 months a year. Property values would collapse. The HOA would probably sue you. Let them. Would they win? Derek shook his head. Not if we're right about the easement terms. Your grandfather included a revocation clause for good reason. He wanted to maintain control. And revocation due to violation of terms is pretty solid legally. Then let's do it. Lucas, think about this. We're talking about making life very difficult for a lot of people who probably aren't involved in this HOA nonsense. Families, kids, people who just wanted a nice house in the mountains. They elected Patricia Henderson to run their HOA. They're responsible for her actions. Derek studied me. This isn't like you, man. You're usually the reasonable one. He was right, but I was tired of being pushed around. Give me another option. Negotiate. Use the threat of revocation as leverage. Make them back off permanently. Maybe get them to formally recognize your property isn't subject to their authority. Everyone walks away intact. And if they don't negotiate in good faith, then you pull the trigger. But at least try the civilized approach first. I agreed reluctantly. Derek drafted another letter, this one more pointed. It outlined the legal deficiencies in the HOA's claims, noted that my property predated their development and was not subject to their authority, and mentioned that I was reviewing the road easement and considering revocation due to apparent violations of its terms. The letter proposed a meeting to resolve all issues amicably. The HOA's response came from Patricia Henderson herself, not an attorney. She called me directly, her voice dripping with condescension. Mr. Vaughn, your threats are pathetic and legally meaningless. We've consulted with our attorneys, and they assure us you have no grounds to revoke anything. The easement is permanent, and your property is absolutely subject to our HOA. If you continue this harassment, we'll add those legal costs to the lien we're filing. Miss Henderson, I'm trying to be reasonable here. No, you're trying to avoid your obligations. You live in Pine Ridge Mountain Estates. You pay your dues and follow our rules. It's that simple. I don't live in your development. My family has owned this land since 1947. And now it's surrounded by a planned community with standards. Adapt or leave. Those are your options. I have a third option. I can revoke the easement that gives you access to your properties. She laughed. Empty threats. Our attorneys say you can't do that. The easement is permanent. Your attorneys are wrong. Read the original document. It contains a revocation clause. Goodbye, Mr. Vaughn. See you in court. She hung up. I called Derek immediately. They're not negotiating. Henderson just told me to adapt or leave. She actually said that, word for word. Derek sighed. Okay, then we move forward with revocation proceedings. It's going to get ugly. I know. The next morning, I drove to the county clerk's office in Kalispell and filed a formal notice of easement revocation, citing the terms of the original 1968 agreement and the HOA's violations of those terms by privatizing what was meant to be public access. The clerk, an older woman named Martha who'd worked there for 30 years, recognized my grandfather's name on the documents. Richard Vaughn was a good man, she said. Helped survey half the county back in the day. He was my grandfather. Then you're doing the right thing. I remember when he granted this easement. He made sure the terms protected his property rights. The county was grateful for the access, but he wasn't going to be taken advantage of. That's the family tradition. Martha processed the paperwork and stamped it official. This will be recorded tomorrow. The HOA will be notified. You might want to prepare for some angry phone calls." The calls started that afternoon. First, Patricia Henderson, screaming about lawsuits and criminal charges for something she called illegal land grabbing. Then other HOA board members, trying various approaches from threatening to pleading. I let them all go to voicemail. The next call was from someone different, a man who identified himself as Gerald Morrison, the developer who'd built Pine Ridge Mountain Estates. "Mr. Vaughn, I think there's been a misunderstanding. Can we talk in person?" His tone was professional calm. I agreed to meet him at a coffee shop in Whitefish the following morning. Gerald Morrison turned out to be in his 60s, a weathered man with careful eyes who looked more like a rancher than a developer. We shook hands and sat down with coffee. "I'll be direct," he said. "Revoking that easement will destroy my development. Property values will collapse, people will sue me, and I'll probably lose everything I've spent the last 5 years building. Then, maybe you should have ensured the easement was properly transferred before building on the assumption you had permanent access. You're right. That's on me." When the county said the road was there and available, I didn't dig deep enough into the details. I assumed because it had been used for decades, the access was established. Assumptions are expensive. Gerald nodded. "They are. Look, I'm not here to threaten you or blow smoke. I made a mistake and now I need to fix it. What would it take to restore the easement?" The HOA backs off. "Permanently. They acknowledge in writing that my property predates their development and is not subject to their authority. They remove any liens they've filed, and they pay my attorney fees." "Done. I'll make it happen." "You can control Patricia Henderson," he smiled grimly. "I own 30% of the properties in the development through an LLC. I have voting rights that exceed hers. If she won't cooperate, I'll remove her as board president." "Why did you let her go after me in the first place?" "I didn't know about it until yesterday. I've been dealing with another project in Bozeman. When I got the notice about the easement revocation, I did some research and realized what had happened. Patricia is zealous about property standards, which was good when we were selling homes, but she's gone too far. That's an understatement. Will you hold off on the revocation while I fix this? Give me 2 weeks. I considered it." Gerald seemed genuine, and he was right that destroying the development would hurt a lot of people who weren't involved in the HOA's decisions. 2 weeks. But I want regular updates, and if Patricia Henderson or anyone from the HOA contacts me with more threats, the deal is off. Understood. Thank you. We shook hands again. I called Derek from the parking lot. The developer wants to negotiate, says he'll rein in the HOA. Do you trust him? My gut says yes, but I'm not canceling the revocation yet. He's got 2 weeks to prove he can deliver. Smart. I'll be ready either way. 4 days later, I received a certified letter from the Pine Ridge Mountain Estates HOA. It was signed by a new president, someone named Michael Chen, and stated that the HOA had been operating under a mistaken understanding of the community boundaries. After consulting with the developer and reviewing original surveys, they acknowledged that my property predated the development and was not subject to HOA authority. The letter apologized for any inconvenience and confirmed that all liens had been withdrawn and all violation notices canceled. Attached was a check for $7,000 covering Derek's fees and my time. I called Gerald Morrison. Got the letter. Is it acceptable? What happened to Patricia Henderson? She's no longer on the board. Her approach was damaging the community. Several homeowners complained once they learned what she was doing. Where is she now? She still owns her property here, but she's not in any position of authority. I made it clear that harassing you or anyone else would result in legal action from the HOA itself. Fair enough. I'll file a withdrawal of the revocation notice. I appreciate it, Mr. Vaughn, and for what it's worth, I'm sorry this happened. Your family has deep roots here. That should have been respected from the start. I thought that was the end of it. I filed the withdrawal. Derek closed his file, and I went back to my normal life of surveying properties and spending weekends at the cabin. Winter came to Montana with its usual force, dumping 3 feet of snow in the mountains and making the road into Pine Ridge Mountain Estates treacherous even with 4-wheel drive. Then, 2 months later, I got another call from Gerald Morrison. "We have a problem." "What kind of problem?" "Patricia Henderson is causing trouble again. She's filed a lawsuit against the HOA claiming she was illegally removed as president. She's also filed something with the county claiming the road easement revocation should have been allowed to proceed and that I conspired with you to defraud the homeowners. That's insane. It gets worse. She's convinced about a dozen homeowners to join her suit. They're claiming the HOA board exceeded its authority by acknowledging your property isn't subject to our rules. They want to reinstate all the violations and liens. I felt my blood pressure rising. She doesn't give up, does she? Some people can't handle losing. Look, my attorney says her suit has no merit, but it's going to cost money and time to defend. I wanted to give you a heads up in case she comes after you directly. Let her try. But Patricia Henderson was smarter than that. Instead of coming after me, she went after the county. She filed a formal complaint claiming that the easement revocation process had been handled improperly, that I had used threats and intimidation to force the HOA into an unfair settlement, and that the county had failed to protect the interests of taxpayers by allowing me to leverage public infrastructure for private gain. The county sent me a letter requesting I attend a hearing before the county commissioners to address the complaint. Derek came with me. The hearing room was packed. Patricia Henderson sat in the front row with her attorney and about 20 homeowners from Pine Ridge Mountain Estates. Gerald Morrison was there too with his own lawyer. The 3 county commissioners sat behind a long desk, looking like they wished they were anywhere else. Commissioner Sarah Peterson, the chairwoman, called the hearing to order. "We're here to address a complaint filed by Miss Patricia Henderson regarding the road easement on property owned by Mr. Lucas Vaughn. Miss Henderson, you have the floor." Patricia stood up, dressed like she was going to court in a sharp blue suit. "Thank you, Commissioner. I'm here representing the homeowners of Pine Ridge Mountain Estates, hardworking families who invested their life savings in property that is now being held hostage by Mr. Vaughn's threats to revoke our only practical road access." She went on for 15 minutes, painting me as a bully who'd used an outdated legal technicality to extort the HOA into abandoning legitimate violations. She claimed my property was a blight on the community, that I'd refused to be a good neighbor, and that the county had a responsibility to protect the majority of taxpayers over one stubborn individual. When she finished, Commissioner Peterson looked at me. "Mr. Vaughn, would you like to respond?" I stood up. "Everything Miss Henderson just said is backwards. My family has owned our property since 1947. We granted the easement in 1968 as a favor to the county with specific terms to protect our rights. The HOA tried to force me to join their organization, threatened to seize my property, and filed illegal liens. I used the legal rights my grandfather wisely preserved to defend myself. That's not bullying. That's property ownership." Derek stood up next. "If I may, Commissioners, I'd like to enter into the record the original easement agreement from 1968, the HOA's threatening letters to my client, and the documentation showing that the developer built an entire subdivision relying on access they never properly secured. This isn't about Mr. Vaughn being unreasonable. This is about an HOA that overreached and got called on it. He handed copies of everything to the commissioners. They reviewed the documents while Patricia Henderson whispered urgently with her attorney. Commissioner John Martinez spoke up. Miss Henderson, according to these documents, Mr. Vaughn's property clearly predates your development. On what basis did your HOA claim authority over his land? Patricia's attorney answered. The HOA bylaws include all properties within the described boundaries of Pine Ridge Mountain Estates. Mr. Vaughn's property falls within those boundaries. But Mr. Vaughn never agreed to join the HOA, correct? Membership is automatic for all properties within the boundaries. Commissioner Peterson shook her head. That's not how property law works. You can't unilaterally impose HOA membership on existing properties without the owner's consent. Mr. Vaughn's property has been in his family for 70+ years. It's not subject to your HOA. Patricia jumped up. But he's using our roads we maintain. Actually, I said, I'm using a road that crosses my property via an easement my grandfather granted to the county. You built your development around an access route you didn't control. That was your choice and your risk. The third commissioner, Robert Jackson, had been quiet until now. Mr. Vaughn, what's your intention regarding the easement going forward? As long as nobody threatens my property rights again, I'm happy to leave things as they are. I withdrew the revocation notice in good faith when the HOA acknowledged their mistake. But if Miss Henderson continues this harassment, I'll reinstate it. Commissioner Peterson looked at Patricia. Miss Henderson, this complaint is without merit. Mr. Vaughn has acted within his legal rights throughout this situation. The county has no grounds to intervene on behalf of your HOA. Furthermore, I'd advise you to consult with a qualified attorney before taking any further action against Mr. Vaughn, because from what I'm seeing here, you're exposing yourself and your HOA to significant legal liability. This is outrageous. You're allowing one man to hold an entire community hostage. No. We're recognizing long-established property rights. This hearing is concluded. Patricia stormed out, her supporters trailing behind her. Gerald Morrison approached me in the parking lot. Thank you for not pulling the trigger on the revocation. I keep my word, but you need to control this situation. I'm tired of looking over my shoulder. I'm working on it. There's a special HOA meeting next week to vote on new bylaws. I'm going to make sure they include language specifically acknowledging that pre-existing properties aren't subject to HOA authority. That should lock this down permanently. Should isn't good enough. I know, but it's the best I can offer short term. Long term, I'm planning to sell my remaining properties in the development and move on. This project has become more trouble than it's worth. I went back to my life again, but with less confidence that the issue was resolved. Patricia Henderson was like a dog with a bone. She wasn't going to let this go. I was right. 3 weeks after the county hearing, I drove up to the cabin for a weekend and found the access road blocked. Someone had installed a heavy gate right at the point where the easement crossed my property line, with a sign reading, "Private Road. No trespassing. Pine Ridge Mountain Estates residents only." I called the sheriff's office. A deputy named Tom Williams met me at the gate 40 minutes later. "This gate is on your property," he asked, "right on the easement line, which means they've blocked access not just to the development but to the federal forest land beyond." Tom examined the gate. "It's new. Installed in the last couple days based on the fresh concrete. You know who put it up?" "I can guess." Tom called it in and got authorization to document the scene. He took photos and measurements. "I'll file a report. You might want to contact your attorney about getting this removed." "Oh, I will. But before I could call Derek, my phone rang. It was Gerald Morrison, and he sounded stressed. "Lucas, please tell me you didn't put up a gate blocking the road." Me, "No, I just found it. I was about to ask if you did." Not me. But I know who did. Patricia Henderson called an emergency HOA meeting last night. I couldn't attend because I'm in Bozeman. Apparently, she convinced enough homeowners that you were planning to revoke the easement again, and they voted to install a security gate to protect community assets. On my property, without my permission. I know. It's trespassing and probably half a dozen other violations. I'm heading back tonight. I'll get the board to remove it. Don't bother, I'm handling this differently. I called Derek. They installed a gate on my property blocking the easement, without your permission, without even asking. What are my options? Well, you could sue for trespassing and demand removal. Or I could revoke the easement for violation of terms. Installing unauthorized structures on my property definitely qualifies. That's the nuclear option again, Lucas. I'm done playing games. File the revocation notice. Today. Derek was quiet for a moment. You're sure, completely? Okay, I'll draft it now and file this afternoon. But Lucas, think about what happens next. Those people are going to lose access to their homes. They have the fire road on the east side. It's not great, but it's usable. And maybe when they're stuck using that rough road, they'll think twice about who they elect to their HOA board. The revocation notice was filed at 4 p.m. that afternoon. By 6 p.m., my phone was exploding with calls. I ignored all of them except Gerald Morrison. Lucas, please reconsider. I'm removing Patricia from the board tonight. The gate will be gone by morning. Too late. The easement is revoked. If your homeowners want access, they can negotiate for a new easement on terms that protect my rights. What terms? I'll let you know after I've consulted with my attorney. But here's a preview. Significant compensation for the access. A formal perpetual acknowledgement that my property isn't subject to the HOA. Personal liability for Patricia Henderson for the harassment and trespassing. And ironclad protections against future violations. That's going to cost hundreds of thousands of dollars. Then you and your homeowners better start a fundraiser. My family granted access as a favor 70 years ago. Favors can be revoked when people abuse them. I hung up and drove to the cabin, parking on my side of the new gate. I walked my property until dark, feeling conflicted. I didn't like hurting innocent people, but I also wasn't going to be pushed around on land my family had owned for generations. The next morning, I found Patricia Henderson waiting at my cabin. She'd apparently hiked in from the fire road because her car was nowhere in sight and she looked disheveled. "You bastard," she said when she saw me. "You've destroyed property values for 60 families. You destroyed them when you installed an illegal gate on my land. That gate was necessary to protect our community from your threats." My threats? I was leaving everyone alone until you started this mess. I didn't join your HOA. I didn't ask to be included in your development. You came after me, and now you're dealing with the consequences. I'll sue you for everything you have. Get in line. But before you do, talk to a real attorney instead of whatever cut-rate hack has been advising you. Because everything I've done is completely legal and everything you've done has been either illegal or borderline. You're holding people hostage, families with children. No, I'm exercising my property rights. Your families should have researched who they were buying from and who controlled their access before dropping $500,000 on a house. That's not my problem. Patricia's face went red. I will make your life hell. You'll regret this. Is that a threat? It's a promise. She turned and hiked back toward the fire road. I called Derek immediately. Patricia Henderson just threatened me in person. I want it documented. Did you record it? No, but I can give you a detailed account. I described the encounter. Derek made notes and promised to send a formal letter to Patricia demanding she cease all contact with me. Over the next week, the situation spiraled. The HOA hired a law firm out of Missoula to challenge the easement revocation. They filed an emergency motion claiming I was causing irreparable harm by cutting off access. Gerald Morrison called twice a day trying to negotiate, and the local newspaper ran a story about the property dispute affecting dozens of families in exclusive mountain community. The emergency hearing was set for 2 weeks out. In the meantime, the residents of Pine Ridge Mountain Estates were stuck using the fire road, which was barely 1 lane wide, unpaved, and increasingly muddy as spring snowmelt began. Several people complained to the county about the road conditions. Others tried to blame me in letters to the editor. One letter, from a woman named Jennifer Barnes, got my attention. She wrote about how she'd bought her house in Pine Ridge Mountain Estates because she worked from home and the peaceful mountain setting was perfect for her needs. She had 2 kids in school in Whitefish, and the rough fire road added 90 minutes to her daily commute. She acknowledged that the HOA had made mistakes, but she pleaded for compassion for families who weren't involved in the decisions. I called Derek. I'm reading these newspaper letters. I feel like a jerk. You're not a jerk. You're protecting your rights, maybe, but there's got to be a middle ground. There is. Negotiate a new easement with proper terms. Make them pay for what they should have secured from the start. How much are we talking? Commercial easements in Montana can run anywhere from $50,000 to several $100,000 depending on the property and usage. Given that this is the primary access for 60 homes and it crosses your land, I'd say $200,000 is reasonable. Plus legal fees, plus the formal acknowledgement of your property rights. That's a lot of money. It's a lot of access. Without it, those properties are worth maybe half what they're worth with good road access. You're actually giving them a bargain. I thought about it for another day. Then I called Gerald Morrison. I'm willing to negotiate a new easement. Thank God. What are your terms? $200,000 paid to me as a one-time fee for permanent access. The HOA formally acknowledges in writing, recorded with the county, that my property predates the development and is not subject to any HOA authority now or in the future. Patricia Henderson personally apologizes in writing and agrees to never contact me again. All my legal fees paid. And the illegal gate removed from my property immediately. That's more than $250,000 total. It's a bargain compared to what those homeowners will lose if they don't have good access. Think about it and get back to me in 48 hours. Gerald called back in 24 hours. The board has agreed to your terms. We'll need 60 days to arrange financing for the lump sum payment, but we can remove the gate immediately and pay your legal fees within a week. 90 days for the payment, but I want a formal contract signed within 2 weeks, and I want confirmation that Patricia Henderson is off the board. She resigned yesterday. Apparently, some homeowners threatened to sue her personally for the mess she created. Smart homeowners. Derek drafted the easement agreement, and it was signed by all parties 3 weeks later. The gate was removed, the access road returned to normal use, and I received a check for $18,000 covering my legal fees. The $200,000 payment came through in installments over the next 3 months. Patricia Henderson's written apology arrived via her attorney. It was clearly drafted by a lawyer and had zero sincerity, but it met the terms of the agreement. More importantly, it included an acknowledgement that she had exceeded her authority as HOA president, and that all her actions against my property had been improper. I thought that was truly the end of it. The new easement was recorded with the county, my property rights were formally protected, and I had a substantial sum of money I hadn't expected. I invested most of it and used some to make long overdue improvements to the cabin. But Patricia Henderson had one more move to make. 6 months after everything was settled, I received a subpoena to appear as a witness in a lawsuit. Patricia Henderson was suing Gerald Morrison and the HOA board for wrongful termination and breach of fiduciary duty. She claimed they had conspired against her, exceeded their authority in negotiating with me, and wasted HOA funds by paying me for an easement that she insisted I had no right to revoke. I called Derek. Now what? Now you spend a day in court telling the truth about what happened. Her lawsuit is frivolous, but you have to participate because you're a material witness. The trial was held in Flathead County District Court in Kalispell. I sat in the hallway for 3 hours before being called to testify. Patricia's attorney, a thin man with wire-rimmed glasses named Stuart Palmer, questioned me first. Mr. Vaughn, isn't it true that you threatened to cut off access to 60 families unless you were paid $200,000? No. I revoked an easement that was being violated. The HOA chose to negotiate a new easement on terms that protected my property rights. But you knew that without that easement, those families would suffer. I knew they'd have to use an alternate route. Whether that constitutes suffering is a matter of opinion. Did you enjoy having leverage over your neighbors? Derek objected. Relevance? The judge sustained it. Stuart Palmer tried a different approach. Mr. Vaughn, did you conspire with Mr. Morrison to remove Miss Henderson from the HOA board? No. I never discussed board composition with Mr. Morrison. But you benefited from her removal. I benefited from the HOA stopping their illegal harassment. Who was on the board was irrelevant to me. The questioning went on for another hour, but Stuart Palmer couldn't shake my basic testimony. I had defended my legal property rights against an overreaching HOA, and I'd been willing to negotiate in good faith once the harassment stopped. Gerald Morrison's attorney, a sharp woman named Catherine Torres, cross-examined me briefly. Mr. Vaughn, at any point did Miss Henderson or the original HOA board attempt to negotiate with you before threatening your property? No. Their first contact was a letter threatening to seize my cabin. And when you raised concerns about the easement, did they respond reasonably? No. Patricia Henderson told me to adapt or leave. Those were her exact words. Thank you. No further questions. The trial lasted 3 days. In the end, the judge ruled against Patricia Henderson on all counts. He found that she had exceeded her authority as HOA president, that the board had acted properly in removing her and negotiating a new easement, and that her claims of conspiracy and wrongful termination were without merit. He also ordered her to pay the defendant's legal fees, which I heard totaled close to $50,000. I ran into Gerald Morrison in the parking lot after the verdict. Well, that's finally over, he said. Is it? Is she going to appeal? Her attorney advised against it. And frankly, she's out of money. The legal fees from this trial wiped her out. She's selling her house in the development and moving somewhere cheaper. I'd feel sorry for her if she hadn't brought it all on herself. Agreed. Look, I know we got off on the wrong foot, but I appreciate you being reasonable in the end. A lot of families benefited. I was always reasonable. Your HOA president wasn't. We shook hands and went our separate ways. I drove back to Columbia Falls feeling like a weight had been lifted. The legal drama was over. My property rights were secure, and I had confirmation that defending yourself isn't bullying no matter how much the other side complains. That summer, I spent more time at the cabin than I had in years. I repaired the roof with new shingles that I chose because they were durable, not because any HOA approved them. I painted the exterior in the original colors my grandfather had used. I kept my firewood stacked the way I wanted it and parked my truck wherever was convenient, and nobody said a word. The residents of Pine Ridge Mountain Estates mostly kept to themselves. A few waved when they drove past my property. One couple stopped to introduce themselves and thank me for being willing to negotiate the easement rather than keeping it revoked. They seemed like decent people who just wanted a nice place to live and got caught up in their HOA's overreach. One afternoon in late August, I was sitting on my porch when a car pulled up. A woman got out, someone I didn't recognize. She was in her 40s with dark hair and a friendly smile. "Mr. Vaughn, I'm Sarah Nichols. I just bought the house 3 doors down from you. Welcome to the neighborhood, I guess." "Thanks. I wanted to introduce myself and let you know I've been elected to the HOA board. We're working on making sure what happened with Patricia Henderson never happens again. Good luck with that. I'm serious. We've completely rewritten the bylaws. Properties that predate the development are explicitly excluded from HOA authority. We've created better accountability for board members, and we've established a dispute resolution process that requires good faith negotiation before any legal action. Sounds like you learned some expensive lessons. We did, mostly thanks to you standing your ground. A lot of us didn't realize how out of control things had gotten until everything blew up, so thank you. I didn't know what to say to that. You're welcome, I suppose. Also, we're having a community barbecue next month. You'd be welcome to attend. No pressure, but it might be nice to meet some of your neighbors under better circumstances." I thought about it. Part of me wanted to stay isolated, to maintain the boundary between my family's historic property and the modern development surrounding it. But another part recognized that these were just people trying to live their lives, and building bridges was better than maintaining walls. I might stop by. We'll see. Sarah smiled. "That's all I can ask. Have a good day, Mr. Vaughn." She left, and I sat on the porch thinking about how things had turned out. I'd inherited a cabin and 40 acres of Montana wilderness, and in defending that inheritance, I'd been called a bully, a hostage taker, and worse. But I'd also stood up for property rights that go back generations, proved that HOAs can't just impose their will on everyone, and ultimately reached a settlement that protected both my interests and those of families who just wanted road access. The easement agreement sits in my filing cabinet now, next to my grandfather's original documents. $200,000 sits in investments, earning steady returns. And my cabin remains exactly what it's always been. A piece of family history maintained on my terms, not subject to any board or committee or self-appointed arbiter of community standards. I did attend the barbecue that September. Met some neighbors, ate some burgers, and had a few decent conversations. Most people didn't mention the easement dispute, though a few thanked me quietly for not keeping the revocation in place. They understood, I think, that I'd been defending myself, not attacking them. As fall arrived and the aspen trees turned gold in the mountains, I reflected on everything that had happened. An HOA had tried to seize my cabin for violations of rules that didn't apply to me. They'd threatened my family's property with liens and legal action. They dismissed my concerns and told me to adapt or leave, but they'd learned, the hard way, that I controlled their only practical road access, that my grandfather had been wise enough to protect our property rights when granting that access, and that pushing someone too far has consequences. In the end, justice wasn't some dramatic courtroom victory or public vindication. It was simpler than that. My property remained mine, on my terms, protected by law and by the careful planning of previous generations. Patricia Henderson lost her position, her lawsuit, and her house. The HOA learned to respect property rights, and the community moved forward with better governance and clearer boundaries. I still survey properties for a living, and I still spend weekends at the cabin my grandfather built. The road still runs through the corner of my land, accessed by an easement that now properly compensates me and protects my rights. And somewhere out there, probably in a more affordable part of Montana, Patricia Henderson presumably complains to anyone who will listen about the injustice of it all. But that's not my concern anymore. I did what I set out to do. I protected my family's land, defended my rights, and proved that even in an age of HOAs and developments and community standards, individual property rights still matter. My grandfather would have been proud. The cabin stands solid against another Montana winter, smoke rising from the chimney I helped him build when I was 12. The land stretches 40 acres in every direction that matters, bounded by fences and deeds and generations of stewardship. And nobody, not Patricia Henderson or any other HOA president, gets to tell me what color to paint it, where to stack my firewood, or whether I belong. Because I was here first, I'll be here last, and the land remembers.